Is Mr. Webster ready,
Lady.
willing, able and available?
I beg your pardon.
Are you ready, willing, able and
I
available?
hope so, madam.
Okay. Thank you very much for your heads of argument.
Lady, we have prepared a bundle of authorities which we make available to you for the court's
Thank you very much. I see that it has just been put before me.
Lady, the accused faces 2 charges, a count of murder and a second count of defeating or obstructing the administration of justice. And at the outset of these proceedings, pleaded not guilty to both counts and puts the state to the proof of the allegations in the charge sheet. It is significant, my lady, that immediately after his plea of not guilty was noted, extensive formal admissions were made in terms of Section 220 of the Criminal Procedure Act, and these included affidavits made by him relating to his movements on the 22nd of February. And I refer the first to Sergeant Sonnenberg on the 23rd of February. This was the day after the event, and it was received as Exhibit J, my lady. It was a fairly brief affidavit, despite the some 3 or 4 hours in interview. It runs to a page, but it speaks of the essence of what he did. And the second, made somewhat later on the 18th of May, which was received as Exhibit K, and that's the document that was subsequently was sent to Twitter. And we say, my lady, that the effect of the formal admissions
Was sent to the HR manager.
That's right. The effect of the formal admissions was to place before the court at the outset of the trial detailed information under oath by the accused setting out his movements on the 22nd of February. It's important because your ladyship was informed of his account of his activities on the 22nd of February before the first witness was called by the state. It's not a situation of an accused pleading not guilty and placing everything in dispute, and he had been doing during the course of that day.
Accepting, of course, now maybe you can explain to me that Exhibit J,
Yes.
paragraph 2, says that his wife went to work at 7, he went shortly thereafter went to work. He doesn't say, I actually went driving around to find another car.
We know that he was interviewed over a period of a number of hours by the investigator.
I'm asking you because you say from the statement I will know exactly what he did, but I mean, I don't.
The 2 statements read in conjunction, Exhibits J and K. The ladyship goes to Exhibit K. You will see at the foot of the first page on the 22nd, heading 22nd of February, is a detailed account of him looking for another motor vehicle for his wife.
Yes, on 18 May only.
It's
So
on the first page of Exhibit K.
that is where I would like you to address me on this aspect, because so the alibi, so to speak, really is only divulged in K, which is on the 18th of May.
Well, lady, the difficulty is, and I deal with this later in my argument, the difficulty is the state hasn't led evidence as to when the death actually occurred. We know, in all likelihood, it was between 7 in the morning and 8:30 in the evening on the 22nd of February. We don't know when it occurred and precisely where it occurred and precisely how it occurred. So it's not a typical alibi situation where you have a particular event that's defined in time to a particular place. It's a situation where at some stage during the course of that day, the deceased died. The accused has given your ladyship, before the first witness is called, in these 2 affidavits, detailed information as to his movements during the course of that day, and he's denied the allegations in the charge sheet. With respect, he can't do much more than that as far as disclosing his alibi is concerned.
Okay.
And we make the submission that there's no criticism to be leveled at him for not putting together a Section 115 explanation of plea, and we submit that he's within his rights in any event not to do so. But he hasn't been coy about what he was doing, my lady. It is there in those 2 statements, and it's there in some detail. My lady, it's trite that the state bears the onus to prove beyond reasonable doubt on each count both the actus reus and the mens rea of the accused in order to secure a conviction, and there's no onus on the accused to prove his innocence, and suspicion does not suffice. This case, in our submission, has had a good deal of suspicion surrounding it. At every turn, there's a finger pointing at the accused. It's a question of what is the reliable evidence and what has been established that the court can rely upon. And I've referred, Your Ladyship, to the Constitutional Court judgment of S.V. Molime, where it was stated, or it was emphasized, that it must be stressed that there's no onus on the applicant to prove his innocence. A mere suspicion, strong as it might be, is not adequate to confirm his conviction. Convictions based on suspicion or speculation, as the court stated in SVT, are the hallmark of a tyrannical system of law, and South Africans have a bitter experience of such a system and where it leads to. That system cannot and ought not in our constitutional democracy be countenanced. And I refer to that, my lady, because, and I'll make the submission in due course, that the manner in which the investigation was conducted, this entire process was targeted at the accused from the outset. And it's our submission that steps were taken not to do an even-handed investigation, but to focus on him and to build a case around him. Lady, the state has called 19 witnesses during the course of its case. The only evidence really as to direct evidence are the two separate incidents of alleged identification by the witnesses Gray and Thomas, and the remainder being circumstantial evidence. Lady, I've set out again the trite law of Rex v. Blom relating to circumstantial evidence and the two cardinal rules of logic which cannot be ignored, that the inference sought to be drawn must be consistent with all the proved facts. If not, the inference cannot be drawn, and the proved facts should be such that they exclude every reasonable inference from them save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be doubt whether the inference sought to be drawn is correct. My lady, the identification evidence of Gray and Thomas, we submit, are central components to the state's case, and they warrant careful scrutiny. They're separate incidents, and clearly, if the identification is reliable evidence, it's significant in terms of the overall picture. But each of those alleged identification situations needs to be assessed, and Your Ladyship needs to make a finding as to whether Mr. Gray and Mr. Thomas individually are to be believed as being reliable. And again, my lady, there is no shortage of law dealing with the correct approach to identification and the caution that must be exercised, and I've referred you to Mtetwa's judgment on page 4 of the heads, where a number of factors are set out, and it's not enough for the witness to be honest. The reliability of the observation must be tested.
Mr. Webster, sorry for interrupting. I just want to understand your sentiments properly. You do accept that Mr. Gray saw a white vehicle without, no, not a white vehicle, saw the green BMW without number plates.
I don't dispute that, my lady.
And you do accept that a white person got into the vehicle and banged the steering wheel?
I accept. Beg your pardon?
That the white person male got into the vehicle and banged the steering wheel?
I can't dispute that, my lady.
Okay.
It's a question of whether his identification...
It's all about who he saw.
Indeed.
I see, okay.
By the same token, it's not disputed that the Audi Q5 was seen driving away from the station later in the day. It's a question of who was the person behind the wheel. It's a question of looking at, in respect of each of those witnesses, my lady, there's a 3-stage process relating to the identification is what happened on the 22nd. Mr. Gray says he was at the corner of Titus and Lucius Way, and he saw this individual. And what he saw and what he could recollect and what he could say on the 22nd and in his statement the next day, allied to that is the second stage, which is the so-called photo identification parade. And the third leg, or the third stage...
Where do I see what he said the next day?
It's dealt with in cross-examination of him.
But I don't have that documentation.
His statement wasn't handed in, but certain significant aspects were put to him in cross-examination, which he confirmed.
And what specific aspect on the cross-examination do you rely on?
I'm going to come to it.
Okay.
What he does say, as far as what he saw on the 22nd, he said there was no clear identification. He could not describe, apart from saying from a distance that he saw a white male get into the motor vehicle. Having driven to that point, he cannot describe the person that he saw momentarily behind the wheel. And the third stage of the process, my lady, is the dock identification. And that applies equally in respect of Mr. Thomas, who saw certain things on the evening of the 22nd, who also went to a photo identification parade, and who also conducted a dock identification. And I'm going to take your ladyship to each of those aspects to consider the reliability, and at the end of the day, to be able to make a proper determination. Is Mr. Gray to be believed in terms of his identification? Is it reliable identification? And the same in respect of Mr. Thomas.
Mr. Webster, about the identification in court, I know you were looking forward and I was looking at what was happening. He started off by saying that's the gentleman, pointing at the accused. We then said it wasn't completely clear, and in all seriousness, the person sitting in the back of the court that he was confused about looked similar and wore similar type of outfit.
Yes.
He then walked and looked at him, came back and put his hand on the shoulder of the accused, who he was satisfied was the right person.
Yes.
The person who was sitting in the back of the court never returned, as far as I'm aware. Maybe once he returned.
He came the next day, my lady, just briefly.
Shortly.
Yes.
Yeah, I will say...
My lady, I will deal with that, and that event is to be found on YouTube. If one wants to see exactly what happened, it is there. And I will deal with that in terms of what it says about Mr. Gray's reliability. But during that incident, he was looking to the back of the court and wasn't very precise about who he was pointing out. And he was describing, he said in terms that there was a person at the back who looked very much like the person.
But start off at the beginning, because the problem with this case is that there is a lot of evidence and it becomes watered down at some stage or other. Initially, his initial view was it was the person sitting there, and he pointed at the accused. The court then said to him, just make sure that you are pointing out the right one, and in all honesty, the court was full of people, and cameras, and shuffling and movement. And I think he should be recommended for the fact that he actually wanted to make really, really sure. And as I say, the person in the back certainly was not completely different. And he went over to go and check, came back, and then put his hand on the shoulder of the accused. Your
ladyship will remember that the point of him being asked to leave the witness box and put his hand on the accused was that his description of the person wasn't that clear. It wasn't a clear situation of saying it's the accused in the dock. He was pointing to somebody at the back of the court. So, and I will address that, my lady, in the course of my argument as to the reliability. But the picture is that Mr. Gray wasn't certain of what he was saying in terms of the dock identification. And there's certain law that attaches to that in any event, and the probative value of a dock identification. But I will come to that shortly, my lady. My lady, the factors enumerated in Mtetwa are in the excerpt that I've put in page 4 of my heads. I don't propose to go into them in any detail, save to say that factors such as lighting, eyesight, proximity, opportunity for observations to time and situation, etc., and the mobility of the scene are factors that the court is called upon to consider in exercising this caution because of the fallibility of human observation. Lady, in addition to that caution expressed in that judgment, Your Ladyship should be mindful of the fact that both Mr. Gray and Mr. Thomas were single witnesses in regard to their separate incidents in which they purported to place the accused behind the wheel of the different motor vehicles at different times. They're not corroborative of each other, they're separate incidents, and each of them are single witnesses.
Except that Mr. Thomas's evidence is regarding the make and model of the vehicle was corroborated. But you accept
But not
that
as the identification, Lady.
That's not an issue for you.
No. And the cautionary rule applicable to the evidence of a single witness clearly applies to the evaluation equally of the evidence of Gray and Thomas in this regard. And I've set out, and I'm not going to read it into the record, Your Ladyship is well aware of the judgments in Rex and McQuena as qualified in Sauls and Stevens. And I ask Your Ladyship to be mindful of the guidelines set by the SCA in Mtetwa as to the evidence as to identification, and also to be mindful of the cautionary rule applicable to the evidence of a single witness. And essentially, the evidence of the single witness should be clear and satisfactory in every material respect. My lady, there's a body of law relating to identification parades, more particularly photo identification parades, which we've referred to in our heads of argument. And the shortcomings of photo ID parades have been spelt out in the authorities. And I refer you to page 7 of the heads of argument. The reference to SV Moti, it's an SCA judgment, where the court said that because the external guarantees postulated for regular identification would be absent, evidence of photo identification parades had to be carefully and even skeptically approached, and the court had to consider whether the identification was properly done and whether the evidence was reliable. In other words, my lady, if the irregularities and the events that occur in the course of that photo identification parade, it is tainted and cannot be regarded as reliable.
You're not arguing that he did not have a fair trial due to the fact that the identification was tainted, or that his rights were affected?
It wasn't a question of admissibility, my lady. It's a question of what is the probative value of that evidence relating to the identification parade. Identification parade was held. It was competent to hold such a parade. The question is, were the guidelines or the parameters set out in the authorities followed, or were they ignored? And if there were irregularities, if the process was tainted by irregularities, it significantly affects the probative value of that photo ID parade.
And the case of Bailey, of Judge Grissel, that was quoted by Ms. Galloway?
All that says, my lady, is that there's not a prescribed set of norms. There's no standing order, there's no set of judges' rules, there's no set of fixed procedures that need to be followed. And pertinently, that judgment says that the guidelines are set out in the case law, essentially. And that's what I've tried to do in the heads of argument. I've referred Your Ladyship to the judgment of State in Shandu, page 8 of the heads, where the shortcomings of photo ID parades are spelled out by the court Inter alia, court says that the difficulty is that their presentation can scarcely duplicate or emulate the conditions of your average identification parade, here referring to photo IDs. The witness is not confronted with a lineup where the suspect gets studied in the company of persons resembling him in countenance, complexion, physique, age, or general appearance. And the court goes on to say, instead, photographs are produced of various suspects whose features may differ markedly, one alone looking like the individual whom the witness saw at the time. And importantly, milady, it's pointed out that the perusal of such photographs is not governed by settled procedures or subject to the strict controls of an identification parade. No safeguards exist against prompting, and there's reference to the controls that have specifically been designed to insulate the witnesses from influence and suggestion.
Do you think that there was an opportunity for influence and suggestion regarding the testimony that we heard?
My lady, my submission will be, once I've gone through the authorities and what happened in the case of the ID parades of Mr. Gray and Mr. Thomas, that the process in respect of both was thoroughly tainted. There were a number of significant irregularities in those procedures, and the processes were thoroughly tainted. And as a consequence, the identification is of no probative value. And in respect of reliability generally, in Moti, reference was made to the fact that what mattered was whether there had been a previous description given to the suspect, given of the suspect to the police which corresponded with the photograph. That is highlighted as a significant factor, and I refer to the foot of page 9 of my head. The instructions that were given on the parade, in particular whether the person was informed that a photograph of the suspect would definitely or might possibly not be amongst the photographs, whether the witness was alone when he made the identification, or whether he was in the presence of other potential witnesses. But lady, I've referred you on page 11 to the judgment of RVY, where reference is made to the importance of holding an identification parade at the earliest opportunity. It was stated in that judgment that it seems most desirable to me in cases where questions of identification are an issue, particularly, of course, where the person involved is a stranger, that details of identification should be investigated at the very earliest opportunity, and that the matter should not be left in abeyance until the very trial itself, when an accused person might find himself suddenly confronted with an unexpected mass of important details in regard to identification. And your ladyship will remember the events in this matter occurred on the 22nd of February 2018, and that the respective identification parades were held some 7 weeks later on the 13th of April 2018.
The wheels of justice move slowly.
Well, my lady, that's not the earliest opportunity. The wheels of justice might move slowly. We know there should have been a live lineup. That is what is called for in terms of the authorities. In terms of what Moti says, a live lineup is what is the preferred course to be followed. And that should also be done at the earliest opportunity. And with respect to the investigator, his protestations that he was unable to find other people matching the description or similar in description to the accused for a lineup just doesn't hold water. 7 weeks later, my lady, he engages in the photo identification process. And we say that this was not held at the earliest opportunity, and that in itself, as a starting point, taints the process. Further, my lady, I've alluded to that in Moti, it was pointed out it would be improper to arrange a photo identification instead of a live lineup after the accused has already been arrested. referring to page 28 of my heads.
28.
Beg your pardon?
28.
I beg your pardon. Paragraph 28 of my heads.
Paragraph.
Not quite there yet.
I thought not.
In that matter, Ninaba J.A. stated the following: onbehoorlik sou dit wees om foto-uitkenning te reël eerder as uitkenningsberade nadat die beskuldigde reeds in hegtenis geneem is. So ook indien 'n foto van 'n verdagte kort voor 'n ooggetuie se identifikasie het sy tydens 'n uitkenningsberade het sy vanuit die getuiebank aan so 'n getuie getoon word. In the instant matter, my lady, the accused was arrested on the 1st of March 2018. The photo identification parade was held on the 14th of April. I beg your pardon, the 13th of April. And in terms of what is stated in Moti, that conduct is both improper and irregular. A further aspect pointing to the lack of reliability of the process is the prior media coverage and photographs of the accused. In the matter of State and Mbule, which I've referred to at the top of page 13 of my heads, a witness had seen a photograph, a newspaper account together with a photograph of the accused. And the court concluded, as a consequence of that no reliance could be placed on the evidence relating to the identification parade. In our matter, my lady, it's common cause that there'd been significant media coverage of the events, which included publication of photographs of the accused prior to holding the identification parade. And as an example, we handed in Exhibit R, which was a front-page photograph from the Voice newspaper.
What date was that published? Because in the Mbuli case that you refer to,
yes,
it was the person saw photographs in the newspaper on the morning before the parade.
But the principle is it was before the parade.
So I understand, but
yes,
I'm quite interested to know what was the date of the Voice.
This was the 6th of March.
6th of March.
Wife killer in court, and a photograph of the accused on the front page with his arm around the deceased. As an example of the type of media coverage there was, we didn't purport to undertake an exhaustive search of all the media coverage, simply to demonstrate the point, my lady. And it was common cause in this matter that there was significant media coverage.
Mr. Thomas said he doesn't read the newspapers and he's not on Facebook. His mother showed him a photograph.
Yes, he saw that very photograph.
On a telephone.
Yes. So he saw an image before he went to the photo identification parade. He saw an image of the accused, whether it's in a photo
and when
image.
she showed it to him, he immediately said that was the man.
I beg your pardon?
When he saw it, he immediately said that was the man. That's a testimony.
The reference to it, my lady, is in the context of the photo identification parade.
Yes, I understand that.
He was shown this. He was shown it by his mother to indicate that that is the deceased. His mother wanted to show him who the deceased was. And in the course of looking at that photograph, he would have seen the accused prior to going to the photo ID parade.
I hear
that is the import.
All I'm saying to you is that there was further testimony. His testimony, as transcribed, was that was the man when he saw the accused standing next to the deceased.
Which he disclosed to his mother.
Which he disclosed to his mother, but, I mean, must I ignore that?
The lady, his mother wasn't called to testify. He says he saw the photograph before the photo identification parade, and I'm going to come to what he said in his statement about what he actually saw on the 22nd. I don't know that it takes the case much further, the lady.
Okay.
We know that Mr. Gray admitted, Mr. Gray, suddenly nobody's reading the newspapers or really paying much attention to the media, despite their involvement. But Mr. Gray admitted to having seen that Facebook image showing the family that was circulated, and again, there was a clear picture of the accused in that image. And he also conceded that he might well have seen other information in the media containing a photograph of the accused. And we say that that factor as well is an additional factor to be considered in assessing the reliability of the purported identification by means of photographs. And then importantly, my lady, the question of the witnesses being in each other's company and together before the holding of the identification parade has been seen to be a significant factor and has been seen to amount to a significant irregularity in the process if the witnesses are together prior to such identification processes being undertaken. And I've again referred you to the SCA judgment of Mbuli at the top of page 15 of the heads, my lady, where it's stressed that the parade should not be conducted in circumstances that allow for prior discussion amongst the witnesses.
Do I remember correctly that there was testimony that there was always somebody present?
No, my lady. The testimony, Mr. Gray didn't take the court into his confidence when he was asked about whether he'd been in the company of Mr. Thomas beforehand. We heard from Mr. Thomas that they traveled from Diep River police station.
With two police officers in the car.
The investigating officer, together with Mr. Gray, with Mr. Thomas, and Mr. Govender, were transported from Diep River police station to Hart Bay police station. They were in each other's company. There was conversation between them. At Hart Bay police station, they were together in the same room.
With a police officer present.
Yes. But plainly, my lady, on their evidence, there was an opportunity for discussion.
Must I disregard that they said that they didn't discuss it?
But they didn't say that, my lady. They said that they had discussions. There was no detail about they denied that there was any detail about the particular identification. But the fact remains that they had the opportunity to discuss it. And in the course of the drive, the most natural thing for these witnesses to do would be to understand what the purpose of their journey was and to share ideas about the person that they're going to identify. And the authority talks about opportunities or circumstances that allow for possible discussion or prior discussion. It's not about establishing that there was actually an exchange relating to the identification of the witness, my lady. The witnesses would not have conceded that in this court if it had happened.
I found the evidence to be very reliable and credible. I did not think that they were hiding things. They had no reason to. So I got the impression that they said, yes, we talked and we both knew what we were there for. Did you get the impression that they were dishonest?
I got the impression, my lady, that certain things happened at an early stage, but at a later stage it became important to adjust the description of the man seen driving the Audi away from the station and to adjust the time. The evidence was tailored at a later stage and didn't fit with the version that was given under oath within hours of the event. And one had a sense that there was an attempt, because it wasn't convenient to refer to it as it was in the original terms, to tailor the evidence. That is my sense. That's as far as Mr. Thomas is concerned. I'm not suggesting that he came to this court with an intention to directly mislead the court, but there was clearly an attempt to tailor his evidence. And in respect of Mr. Gray, and I will argue in due course, seemed to be confused and not very sure of himself or very sure of his facts. The point I'm simply making, my lady, is that in terms of the authority, if the witnesses had been together and had the opportunity for prior discussion before the identification parade was held, that constitutes a further irregularity in the process. My lady, one doesn't require a string of irregularities or improper conduct to taint the process. One of these factors would be sufficient, but this is yet a further factor to be considered. Then, my lady, about the instruction given. I've referred you to the judgment of Narasamy, which dealt with the instruction given. And the importance of the instruction given is that there should be the rider added if such person is present on the parade. And I refer you to page 16 of my head. Where the court said the following: another irregularity which tainted the proceedings is the way in which the police officer controlling the identification parade instructed the identifying witness. Further on, in my opinion, it is important that officers holding identification parades should add the important words, if such person is present on the parade. Otherwise, a witness, particularly an illiterate one, might think that it is his duty to point out somebody in an act of disrespect to or criticism of the police if he's not able to do so. In this matter, my lady, the instruction given to Gray and Thomas respectively was simply that they were required to identify the person without the rider being added if such person is present on the parade. The instruction was, find the suspect in the images. And we say, my lady, that on this basis, the instruction was irregular and further tainted the respective identification parade proceedings. I've referred you, lady, to Staten and Dika, page 17 of the heads, where Murray J.A. said the criticism of the photographic identification parade is not without merit, and so far as it concerns the general principle of such methods. And he says, what is clear, however, is that if such a method has been used, it's not axiomatic that the results are to be ignored. There was a view taken at a stage that any identification parade should be ignored. What the learned judge says, all will depend upon whether there is a reasonable possibility that improper conduct has tainted the reliability of the identification, or that even in the absence of any improper conduct, the objective circumstances attending the photographic identification were not conducive to accuracy and reliability. And my lady, in terms of what I've taken you through, we make the submission respectfully that the circumstances of the respective photo identification parades are such that they are tainted by a range of irregularities and cannot be relied upon. It's not a case of just one or two, there are a string of irregularities in respect of each. Lady and I deal briefly then with the authorities relating to a dock identification, as this was the third phase of the so-called identification process by both of the witnesses. And in Moti, the court held that a dock identification is suspect per se, and I refer to the extract on page 18 at paragraph 43. And in State v. Maradu, the court said that, to my mind, the danger of dock identification is the same as that created by a leading question in examination in chief. It suggests that the answer desired. As the latter type of question is inadmissible, I see no reason why a dock identification should also not be inadmissible, save in certain special circumstances. In the present case, there are no such special circumstances. And then the SCA, more recently dealing with dock identification, says, dock identification, as our previous allusions to it in this judgment indicate, may be relevant evidence, but generally, unless it is shown to be sourced in an independent preceding identification, carries little weight. Taken on its own, it is suspect. The reason is apparent. It is clearly a danger that a person might make an identification in court simply by seeing the offender in the dock. He had become convinced that he was the offender. And further, that where the state relies on a dock identification, these questions carry little weight. The witness can look at the accused in court, as happened in the present case, to the indignant objection of the accused and their counsel. Under these circumstances, dock identification is similar to a leading question. As a result, in certain circumstances, it could carry no weight at all. Thirdly, I then go on to deal with Mr. Gray's evidence relating to identification. Is your lady wishing to take the tea,
I've been in court since 9. I wouldn't mind a quick opportunity to go and have a cup of tea.
Thank
and
you.
You can have a glass of water or a cup of tea or coffee.
Thank you.
I will be back at 12:30 if that's in order with everybody.
As the court
will adjourn.
pleases.